Imagine waking up to find military troops patrolling your city, not because of war, but because the president decided to send them there. That's what this Senate clash is about, where the line ends between public safety and martial law.
Soon, Senator Durbin.
Thanks, Mr. Chairman. At our last meeting last week, two of my Republican colleagues defended President Trump's unlawful attempt to deploy the Texas National Guard to my home state of Illinois. I want to take a moment to respond. One colleague compared Trump's actions to President Eisenhower deploying the 101st Airborne Division to desegregate Central High School in Little Rock, Arkansas in 1957. Most of my colleagues here are too young to remember the civil rights movement, but there is no comparison between Arkansas's massive resistance to desegregation and Illinois' peaceful and lawful opposition to this administration's immigration policy. Arkansas Governor Orville Faubus called up the Arkansas National Guard to block black students from entering Little Rock Central High School in defiance of the Supreme Court decision in Brown versus Board of Education. The 101st Airborne, dispatched by President Eisenhower, was deployed to ensure these students, the Little Rock Nine, as they were known, could safely attend school. They weren't tear-gassing pastors, journalists, and police officers, as the federal agents are now doing in Broadview, Illinois, a suburb of Chicago. They didn't rappel from Black Hawk helicopters in the middle of the night to swarm an apartment building, breaking down doors, rousting families out of bed, zip-tying and detaining U.S. citizens, including children, as federal agents did in Chicago's South Shore neighborhood 2 weeks ago. That is a fact. And then the senior senator from Texas compared my opposition to Texas National Guard being deployed to Illinois, to southern states defending the institution of slavery. He said, and I quote, attempting to resurrect a long-rejected idea associated with slavery in the early days of the United States, that the state and local officials can nullify federal law. The senior senator from Texas is a good lawyer, and he's well aware of how limited that comparison is. I'm not arguing that states can override federal law. I'm arguing that President Trump is violating federal law. Don't take my word for it. Judge Karen Immergut, a conservative Republican appointed to the federal bench by President Trump, blocked the deployment of the National Guard in Portland, Oregon. Listen to what she said, and I quote, and let me remind you again, a Trump appointee, quote, this country has longstanding and foundational tradition of resistance to government overreach, especially in the form of military intrusion into civil affairs. This is a nation of constitutional law, not martial law. That's what the judge said. Or listen to Republican Oklahoma Governor Kevin Stitt, another conservative. And he said, quote, Oklahomans would lose their mind if Pritzker, Governor Pritzker, in Illinois sent troops down to Oklahoma during the Biden administration. I'm sure they would have. And I'm sure at a guarded moment and by secret ballot, every member of this committee would agree. Here's the reality. The president's actions are about politics, not public safety. For the past 2 decades, the murder rate in red states has exceeded the murder rate in blue states. But the president is focused on Chicago, where violent crime is down dramatically. We should build on that success and work together, not undermine it. As I told the Attorney General, it is my job to ask fundamental questions about whether the federal government is following the law and Constitution. But she refused to tell me when I asked what was the legal basis for deploying the National Guard in Illinois. Instead, she launched irrelevant and false personal attacks. In more than 2 decades on this committee, I've never encountered a witness from any administration, Democrat or Republican, respond to legitimate oversight questions with personal attacks on the senators on this committee. That testimony by the Attorney General demonstrated the disdain she has for this committee and the constitutional responsibility we share to conduct oversight, regardless of the party in charge in the White House or Congress. We also need to hear from Department of Homeland Security Secretary Noem. She made time to go to Chicago for a glossy promo video but she refuses to meet with me and Senator Duckworth. She won't respond to our oversight request and denies us access to detention facilities in the state we represent. We were there last Friday. There were demonstrators there. In the course of the day, 4 were arrested and detained. It was a quiet day. People were exercising their constitutional rights in a nonviolent fashion, as they should. When I was chair of this committee, I held a DHS oversight hearing with Secretary Mayorkas during the first year of the Biden administration. He faced tough questions from both sides of the aisle. You probably remember it. Unlike the current Attorney General, he didn't insult this committee with his responses. Mr. Chairman, we sent you a letter in June asking when Secretary Noem would appear before the committee. I hope, again, for the record, you'll make it clear that that is going to happen soon.
Senator Durbin, would you yield for a question?
Yes, of course.
Thank you.
We don't
You
have
said
it
that you said
scheduled
the
yet,
president
but we're-
violated federal law, and what federal law did he violate by sending National Guard troops to Chicago?
Well, the question is, what federal law did he follow to send those troops, and he couldn't produce it in the court in Oregon?
I'm sorry, I didn't understand that.
It's been contested as to whether he has the authority to send in the National Guard. In the court in Oregon, I just quoted the judge. There is no basis for his doing
Well,
so.
you didn't say what federal law, what law he violated. Is it illegal for him to send federal officials there to enforce
There are legal
federal law?
authority. There are legal authorities for him to do it, and he hasn't been able to establish in court successfully that he's followed them.
Well, I wish if you're
fact,
going to
he
accuse
keeps
the president of violating federal law, that you could actually tell us what law you
Well,
think he
I asked the
violated.
senator from Texas, why does he keep bringing up the Insurrection Act?
Well, he hasn't asserted any right under the Insurrection
For
Act.
good reason. There is
But
no
this
basis.
is, to answer your point about the border, in the absence of federal law enforcement along the border, or actually when the open border policies of the Biden administration were in place, Border Patrol was overwhelmed, so Governor Abbott sent National Guard and Department of Public Safety to the border to back up the border
Of his own
patrol,
state?
not to enforce the law,
State,
but to
Texas?
supplement their efforts so they would free them up so they could deal with the challenges that they had as a result of being overwhelmed.
Were these border areas in your state of Texas?
Say that again?
The border areas that the governor sent the National Guard to, were they in Texas?
Yeah.
Well, that's a totally different story than we're facing in Illinois.
We, yeah,
Well, since I was referenced, I just would like to respond.
You want to speak to this issue, or?
Yes.
Okay.
Yeah, briefly. Well, specifically, the president has cited Title 32 authority to send the National Guard there. I can understand the sensitivity from my Democrat friend, because Democrats were on the wrong side of these issues. The Democrat governors opposed Reconstruction. The Democrat governors opposed desegregation, which I cited last week in Arkansas. And now they're on the wrong side of law, opposing the protection of American citizens and law enforcement who are doing their jobs, which is to enforce federal immigration law. The president has every authority to send the National Guard to protect those ICE agents and protect federal facilities. The fact that J.B. Pritzker wants to be known as sort of the resistance right now is not an excuse to say that the president's violating federal law. He's cited federal law. He's cited Title 32 in doing his job in protecting the American people. So,
I was going, first of all, I want to respond to my ranking member that we're trying to get a meeting with Secretary Noem.
Sooner the better, Mr. Chairman.
Okay. Senator Whitehouse, if you're going to speak 5 or 10 minutes, I'd like to call the roll, and then I'll call on you, but if you...
That's fine.
Is that okay?
Yeah, what I want to do is just to make a record regarding the substance, the procedural substance of some of the questions that I asked Attorney General Bondi that she just flat out refused to answer. So if you want to proceed with the votes, that's fine with me, as long as I'm recognized at the conclusion of the votes.
Thank you for your cooperation.
This exchange between Senators Durbin and Cornyn is short on theatrics but huge in consequence. It pulls back the curtain on a constitutional fight we're seeing play out in real time. When can a president send soldiers into American cities? Who decides? And what stops that from turning into martial law? Durbin's core point is simple and serious. This wasn't a straightforward law enforcement assist. It was an extraordinary use of military force in a peaceful, governed state that hadn't asked for troops. A federal judge in Oregon recently agreed with that instinct, temporarily blocking a similar deployment and writing that this is a nation of constitutional law, not martial law. That ruling, from a judge appointed by the president whose action she blocked, matters because it frames the legal question as one of limits, not convenience. To understand why the moment matters, you need to know the legal tools at play. There are different authorities presidents and governors can invoke when Guard troops move. Title 32 keeps Guardsmen under state control while the federal government pays for certain missions. Title 10 federalizes them and places them under Pentagon control. And the Insurrection Act is the narrow statute that allows the president to use federal troops to suppress insurrection or enforce the law when states can't or won't. Those distinctions aren't technicalities. They determine who's in command, whether the posse comitatus restrictions apply, and whether ordinary domestic law enforcement norms are being overridden. The National Guard's duty status and the limits on military participation in civilian policing are complicated, and courts have repeatedly pushed back when administrations treat those rules as optional. That's why the historical comparison Cornyn invoked, Eisenhower sending the 101st Airborne to Little Rock in 1957, is deceptive if you use it as a straight parallel. Eisenhower federalized the Arkansas Guard and sent troops to enforce a clear Supreme Court order against state officials who were actively defying federal law. The point then was to protect citizens' constitutional rights from unlawful state actors. By contrast, the recent deployments at issue were justified by the administration as protecting federal property and enforcement actions in places where state and local officials objected and where courts have questioned the factual basis for claims of lawlessness. Historically, the president's military interventions inside states were aimed at enforcing federal law against state obstruction. The current pattern looks more like federal forces being used to carry out politically charged enforcement actions inside states that are complying with the law, and that difference is legally and morally important. Courts have not been merely academic observers here. Multiple federal judges have scrutinized and, in at least some cases, blocked deployments, finding the administration's legal justifications thin and its factual claims exaggerated. One judge concluded the government failed to show the city was war-ravaged or experiencing conditions that would justify a military response. Another recent ruling found that the administration's troop use in Los Angeles crossed legal lines under the Posse Comitatus Act when soldiers were used for crowd control and arrests. Those rulings aren't ideological outliers. They highlight the judiciary's role as a check when executive power stretches long-standing limits on domestic military use. Politically, Durbin's confrontation with Cornyn exposes why this is more than a technical legal spat. It's a test of norms. When a president treats Title 32 or other authorities as flexible levers to insert troops where state officials don't want them, or when federal officials escalate force in places with active critics and reporters, it erodes the practical boundary between civilian policing and military power. That erosion is exactly what the Posse Comitatus Act aims to prevent. Mixing the military into routine domestic law enforcement risks normalizing force where civilian oversight and accountability should rule. There's a political logic on display too. Deployments framed as protecting federal facilities or ICE operations often land in cities where those federal actions are themselves controversial. That turns what might be a narrow operational decision into a national constitutional conversation. Whose safety counts as the rationale for military presence, and who gets to decide? Durbin's insistence that the administration show what law was violated is more than rhetorical theater. It's a demand for the documentary record that courts and democratic oversight require before the extraordinary step of using armed forces in domestic affairs becomes routine. For viewers trying to make sense of what happened in that back and forth, the senators are doing different jobs. Cornyn is pushing the narrow question, name the statute, to force Durbin to be specific. Durbin is answering at a higher constitutional level. Courts and precedent show the administration couldn't establish the factual and legal groundwork for these actions. The result is the same practical message. Legal authority for moving troops inside the U.S. is not limitless, and the judiciary is willing to step in when presidential action looks like overreach. What should citizens take away? First, these aren't abstract debates about doctrine. They are debates about civil liberties and the balance of power. Second, the law still matters. Judges are reminding a president that the Constitution and federal statutes place boundaries on the use of military force at home. Third, oversight isn't optional. When senators ask for evidence and when courts demand it, they are doing the civic work that prevents policy from sliding into unchecked power. If you want to understand how these moments shape the next election, the long-term role of the National Guard, and what legal standards courts are now applying when presidents try to deploy troops at home, subscribe to Left Lens. We'll follow the rulings, explain the statutes, Title 32, Title 10, the Posse Comitatus Act, the Insurrection Act, in plain language, and show the human stakes behind the legal memos. Because these are the rules that protect everyday life from becoming a battlefield. Key sources for this breakdown: the recent Oregon federal court opinion blocking deployment, Judge Curran Immergut, analyses of Title 32 and National Guard duty status, and recent rulings applying the Posse Comitatus Act to troop deployments in U.S. cities.